Good afternoon. My name is Esther Bigler, and I direct the Labor and Employment Law program here at the Cornell ILR School. Usually we are on 34th Street. We moved from 34th Street. We are on Lexington Avenue and 50th Street. So this is quite new for all of us, this virtual webinar. A few administrative issues to talk about. This is a CLE program, and so at the end of the program, there will be an evaluation, and we will ask you to fill out the code for the CLEs. There will be a code that I will announce midway through the program so that you can apply it for your CLEs. All the materials for this program are on the Labor and Employment Law website, as well as everyone's biography. During the presentation, you will be able to post questions in the Q&A box. You will not be able to post in the chat box at all. We will be reading those questions, and at the appropriate time, we will be trying to answer all of the questions that you have posed. When you pose questions, if you have one for a specific person, please let us know who you would like your question addressed to. Today's program takes place during a pivotal moment in American history. There are protests in the streets during a COVID-19 pandemic. Both the protests and COVID-19 will forever change our country, our lives, and I think the employment relationship between employees and employers. Today, Cornell is on pause for a moment of self-reflection after the death of George Floyd. We decided to go forward with this program nevertheless because of the urgent issues that COVID-19 has raised and the fact that African Americans have suffered and died in much greater numbers than whites with respect to this disease. So we thought that this was something important to go forward with. It is my job as Director of Labor and Employment Law to bring you current legal issues. Today, as businesses open up around the country, and in our own New York State, the federal government and various state governments are wrestling with the issues raised by the COVID-19 illness and the deaths of so many Americans. How do we compensate employees and their families for their injury and their deaths? At the same time, governments are asking another question. They're asking, do businesses need liability protection? Or as some people refer to it, a liability shield for these very same COVID-19 related injuries. Finally, do we need, as we had after 9/11, a national fund? This is a national pandemic. Indeed, it's a worldwide pandemic. How do we deal with all of the people who've been affected by this disease? Today, we will examine the negligence standards, the role of workers' compensation, and then ask the question, after we've talked about those, do businesses need a liability shield or protection? And should we really be establishing the kind of fund we had after 9/11? How do these all relate to each other? Our speakers today are John Beisner, who is a partner at Skadden and a leader of the Mass Torts, Insurance, and Consumer Litigation Group. He focuses on the defense of purported class actions, mass tort matters, and other complex civil litigation in both federal and state courts. And he has often worked with the United States Chamber of Commerce on the Institute for Legal Reform. Joseph Cannabis is a special counsel to the New York State AFL-CIO. He works with the Federation's legislative, political, communications, and field departments to further pro-worker policies and initiatives. Robert Schnatzel has 40 years of experience involving workers' compensation insurance matters. From 1995 to 2003, he served as the chair of the New York State Workers' Compensation Board. Following the September 11 attack on the Twin Towers, he led the New York State Workers' Compensation Board response to thousands of injury and death claims arising out of that attack. Bradley Wendell joined the Cornell faculty, the Cornell Law School faculty, in 2004 after teaching at Washington and Lee Law School. Before entering graduate school and law teaching, he was a product liability litigator. His teaching interests are in the regulation of the legal profession and torts, and his research focuses on the application of moral and political philosophy to the problems of legal ethics. I am going to pose questions to each of our panelists, and then I'm going to ask the panelists to respond to what they have heard from each other. And finally, we will open it up to you for your questions. And hopefully our panel will be able to answer all of them in the time allotted. Brad, to begin our discussion, could you please give us a brief overview of the negligence standards or tort liability of employers as it relates to employees who are injured on the job or have work-related occupational diseases, particularly with reference to COVID-19, if you can?
Yeah, sure. Thanks, Esther, for the introduction. And in the audience, don't worry, despite what she said, I won't be talking about moral philosophy at all. Yeah, I am, as she mentioned, I'm a former products liability lawyer, and I teach torts, and I'm not going to talk too much about workers' comp. There are other folks on this panel who know a heck of a lot more than I do about workers' compensation, but I do think it's important to just draw a couple of distinctions, really, when people are reading in the news about what's going on in terms of advocacy for liability shields or compensation funds or things like that. It's just important, first off, and many of you are lawyers, so you know this, but it's important to distinguish whether we're talking about workplace injuries, which are within the workers' compensation system, or whether the claims are those that are raised by customers, third parties, or others related to COVID exposure. So a couple of days ago, there was an article in the Washington Post about a Connecticut liability shield for nursing homes. And this was not about nursing home employees. This was about residents and their families and the claims that they could raise against the nursing home owners for mismanagement, basically negligence. These aren't workers' compensation claims. And so it's important to, at the outset, keep those distinctions straight. It's also important, I think, to keep in mind the purposes of tort liability and negligence liability at all. And that is, it's a multi-purpose system. One purpose is to create accountability and avenues for redress. So people who are harmed by accidental injuries have a way of finding out what happened and holding responsible those who caused the harm, and also creating incentives on the part of actors to behave safely and take appropriate precautions. There's also a compensation function. We don't have the same level of social welfare support that a lot of other countries do, and people who face accidental injuries can face catastrophic medical bills or become homeless and often require a source of compensation to restore them to the place they were before their injuries. And the tort system and the workers' compensation system both aim to do that to some extent. And on the other side of the balance is the concern that excessive tort liability either will be arbitrary and standardless, or will simply become so ruinous of a burden that providers of useful goods and services will be driven out of business or withdraw from the market. And so the tort system really aims to adjust those policies and to strike the appropriate balance. And the general negligence standard, which applies not to workplace injuries, but to customer or third-party injuries, is really simple. And all of you who are lawyers will remember this from torts. It's reasonable care under the circumstances. And the important part is under the circumstances. And so any defendant in a tort lawsuit will have an opportunity to show that they behaved as a reasonable person would have under the circumstances, including an emergency. So if a hospital or a nursing home or some similar institutional defendant was struggling with shortages of protective equipment and was swamped by patients and excessive cases, that's part of the circumstances that should be taken into account. One of the reform proposals you'll sometimes also see is some kind of safe harbor for compliance with federal or state regulatory guidelines, OSHA or CDC guidelines or something like that. That's a relatively minor tinkering with the law. As it stands, compliance with federal regulatory or state regulatory guidelines is not conclusive of negligence, but it's something that could be taken into account by a jury. So that would be a relatively minor reform, but maybe not a bad thing. Now, the subject of liability shields or compensation funds is interesting, and that's its own topic, but worth mentioning here. There have been a lot of different mass events that have led to the creation, either by legislation or by judicial act, of some sort of compensation fund. So Esther mentioned the 9/11 Victims Compensation Fund. There's also the BP oil spill fund administered by the ubiquitous Ken Feinberg. There's a thing called the Vaccine Injury Compensation Program for people who claim injuries related to vaccines. That's funded by vaccine manufacturers. Probably the opioid litigation in Ohio will end with the establishment of some kind of judicially created compensation fund. And the idea behind all of these funds is to create some kind of relatively speedy remedy for people who have been injured, taking down some of the adversarialness of the litigation system, sometimes also looping in neutral experts. So in cases that involve fairly technical determinations, medical determinations, you can bring in physicians or public health people or engineers or whoever has the relevant expertise to ensure more accurate adjudication. One of the questions is, how well do these things function? Do they do better than the tort system? And I think one of the aspects of this debate is a background, really a drumbeat that business interests have been keeping up for the past several decades about the tort system, which has led to quite a bit of folklore about the prevalence of frivolous litigation, runaway juries, excessive verdicts, and things like that. That may bias the debate towards something like a liability shield or some kind of compensation fund. It's worth asking whether it's true, actually. It's worth asking whether liability is really out of control, frivolous lawsuits really are a big problem, or something like that. I think John Beisner will probably have a lot to say about that in his portion of the talk. But it's worth noting that these compensation funds are not necessarily a panacea. One of the articles that I put up on the website is by a friend of mine, Nora Engstrom at Stanford, who has studied the vaccine injury compensation program, and has shown that it really doesn't necessarily do all that its proponents claim that it should do. So it's just, as we talk about all these different options, it's worth thinking again in terms of the goals of accountability, compensation, and not saddling businesses with ruinous liability expenses. As we talk through all these different alternatives, let's just think about which one of those accomplishes the right balance among those competing objectives.
Thank you so much, Brad. Joe, if you could spend a few minutes talking to us about the Workers' Compensation Board and the workers' compensation law. We all know, but I think it bears reiteration, that an injured worker covered by workers' comp does not have recourse generally to sue his or her employer. And so the question becomes, what are the limits of liability when there is workers' compensation, and what are the benefits that employees have by being covered by the workers' compensation?
Great, thank you, Esther. I appreciate the opportunity to speak. So I'm glad that you posed the question the way that you did, because when we talk about workers' comp, we often fall into the trap of talking about the benefits and only the benefits and what's available to workers. And we don't look at the other side of the coin. You know, the workers' compensation system in New York is over 100 years old. It was the original liability shield for employers. Employers, except in very, very limited circumstances, employers are protected by the workers' compensation law. It's the exclusive remedy for injured workers. Occasionally there is an opportunity for an injured worker to sue a third party if there's a third party that's liable as part of the injury or the illness. But for the most part, injured workers are limited to workers' compensation. In New York, workers' compensation wage replacement is up to nearly $49,000 a year, the limit. And an injured worker has all of their medical care paid for, medical care associated with the injury or the illness paid for. Now, a couple of important points. The way that the benefit is calculated is that an injured worker would receive 2/3 of their average weekly wage, capped at 2/3 of the statewide average. So the statewide average on a yearly basis is just shy of $49,000 for this year. However, that's only if the injured worker is 100% disabled. That's a pretty high bar to reach. If they're only 60% disabled, then they're looking at 60% of that. So the benefits are real, they're substantial, and for a worker who dies as a result of a workplace injury or illness, their specific survivors can receive their wage replacement rate and any of the care that worker received before they passed should be covered. 100 years ago, this was treated more like an insurance product. You go in, you make your claim, you get paid. Now it's almost like a separate parallel litigation system. Injured workers, except for those with acute injuries that heal fully and quickly, almost always need an attorney to help them navigate what should be a relatively easy, simple system. Back to the death benefits. Survivors. Surviving spouses who don't remarry can collect the deceased worker's wage replacement rate either for the rest of their life or until they remarry. If there's no surviving spouse, the survivor benefit can be or a minor child up to the age of 18 or 23 if they are enrolled in school, can collect that survivor benefit. And if there's no surviving spouse or minor children, a true dependent could collect that wage replacement benefit. But it's not someone who just depended on the deceased worker. It has to be someone who can show that they can't take care of themselves, and that deceased worker took care of them. So I think along the lines of a developmentally disabled adult child or possibly a developmentally disabled adult sibling. Barring any of those, it would be a one-time $50,000 payment, or if none of those people could collect the benefit, it would be a one-time $50,000 payment to either the deceased worker's parents or to their estate. Those two are mutually exclusive, and then on top of that, there's a funeral benefit of up to $12,500. It varies based on where you are in the state. So this is not an insignificant amount of money. And in terms of the current conversation, we've already seen some employers and carriers in New York challenging these claims. Brad spoke a little bit about workers' compensation claims for COVID. Very basically, everybody in New York State, every employee in New York State who's covered by the workers' compensation law, there are a few exceptions, but everybody who's covered, if those people contract COVID as a result of a workplace exposure, they're entitled to benefits under the workers' compensation law. Even if they're just exposed to COVID and they have some expenses at the workplace and they have expenses associated with testing, and they don't ultimately contract it, they're covered under the workers' compensation law. However, it's a matter of proof, and the proof issues that are involved in workers' compensation are going to be similar to the proof issues that are going to be present in negligence. However, workers' compensation in the workers' compensation system, over the years, a body of law has developed to determine what is a workplace injury, or what is an occupational illness, and what would be treated as an injury. So, Esther, for me, I'm not at particular risk to exposure to COVID-19 because of my work. I work in an office. I do travel a bit. I spend some time up in Albany, but I'm not dealing with the public. I don't work in a service center. I'm not checking people out online. I am not operating or helping to operate a bus or a train. I'm not a healthcare worker. Those types of workers who are exposed to COVID-19 as a result of their work, the nature of their work makes it more likely they're going to have a much easier time than someone like me. For someone like me, it would be treated as an injury. I would be covered, but I would have to go back and prove who I was exposed to. So I would have to say I was at X meeting, and at that meeting, I encountered this individual who I later learned, had COVID-19, and that's how I would attempt to prove my case. With someone who works in healthcare, there's like I said, a body of case law, decisional law, both board decisions and court decisions that would lower that person's standard, or not lower their standard, but would make it so that they would simply go in and allege, I work in a healthcare institution. We treated COVID patients. I came down with COVID-19 as a result of my work. Still, though, the insurance companies and the employers could ask questions, the same questions that they would ask in a negligence case. Isn't it true that your spouse, your roommate, your child, someone that you live with, contracted it before you did? And isn't it more likely that you got it from them as opposed to your workplace? Isn't it true that you weren't adhering to social distancing recommendations? Here, let me ask you this question about the social media post where you were at a party or you were on the beach. So even though that those types of workers would be more likely to be covered, it doesn't mean that it's a sure thing. What's troubling in the context of this conversation is that it seems to me that some of these businesses are articulating that they need protections that they already have. So in my mind, if they're saying that they need protections that they largely already have, you have to make the next logical leap here, which is that they want things that they're not articulating. And one of the things that I believe that they're interested in exploring is immunity from workers' comp claims. And I want to point out that one, even in workers' compensation, this is going to be a difficult thing to prove as is under current law. These employers have already paid for this coverage. This is an insurance product. They've paid premiums. There are some employers who are self-insured, but they've paid premiums. And insurance companies, large employers, they have actuaries, they have underwriters, they have people who help them figure out the likelihood of just about any possible calamity that could strike a business or its employees. And they have they've forecast for this, they've underwritten for this, whether it's a pandemic or any other type of catastrophe. They've built it into their pricing. And from my perspective, they should be required to pay out on valid claims.
Thank you, Joe. John, you've now heard a discussion of negligence and negligence theory, and you've heard discussion about the workers' compensation system. So my question to you is, so why the need for liability protection? Aren't employers protected enough under the system of tort law and workers' compensation?
Well, Esther, first of all, thank you for inviting me to participate in this very timely discussion today. And let me respond to your question by first offering some clarification about my understanding of what's being proposed. Right now, there's no federal legislation to look at. Nothing has been introduced in Congress. But if you examine the correspondence members of Congress have been receiving from the business community, from colleges and universities, and from nonprofit organizations. The concerns are as follows. Some businesses and nonprofits provide what are undeniably essential lifeline goods and services, particularly foods, medical services, medicines. And during the pandemic, many of them answered the call to remain in operation so we wouldn't all have to go without food, healthcare, and other things. And my sense is that generally speaking, they tried to observe governmental guidance about how to deal with the COVID-19 threat. But they fear that their efforts to serve the public during that period are going to be rewarded now with lawsuits brought by individuals who contracted COVID-19 and suffered its awful consequences. And I'm talking about lawsuits alleging that plaintiffs contracted COVID-19 because of his or her presence at the targeted business, school, or nonprofit facility. And as Brad said earlier, I'm talking there, I guess, about two primary categories. That's customers of these facilities and then employees there. And I think there's concern that looking forward, many businesses, educational and educational institutions and nonprofit services that weren't in operation during the pandemic will be strongly discouraged from reopening because of this lawsuit threat. Now, I heard Brad say earlier, he talked about the standards of proof in negligence cases and that what is supposed to happen there is a judgment of one's behavior under the circumstances. But I think the concern is about what's really going to happen in courtrooms at trials. And I think the lawyers who bring these cases will tell juries stories that evoke considerable sympathy. And I'm not saying that sympathy is wrong. They're going to talk about people who died as a result of COVID-19, who were intubated, and so on. But they're going to argue to juries that it was negligence for the defendant to be open at all, because no one can guarantee that a facility is totally free of the virus or guarantee that none of the other persons at the facility, the customers, the employees, isn't contagious. And I think we'll work to try to point out things that the business could have done better and so on. And that combined with the sympathy makes these much stronger cases than one might otherwise think, even under the negligence standard as Brad laid it out. Now, I don't want to be suggesting that I think these cases are generally meritorious, far from it, as both of the previous speakers referenced. I think the biggest problem in all of them is showing causation. As a matter of science, there really isn't any way for a person to prove that he or she contracted COVID-19 from contact with a particular person or other source. The virus carries no source signature, as the term is used. And although a lawyer may argue that his or her client contracted the disease by visiting a grocery store on a particular date, contract tracing in most cases that would happen after the lawsuit is filed would show numerous other potential sources, other persons or places with whom the plaintiff had contact in the same time frame. So in light of that, what legislation is being proposed and why? And again, since there's no federal bill for us all to stare at, what I'm talking about here is admittedly somewhat speculative. But what I hear being discussed isn't any sort of an absolute immunity or an absolute shield. What's being floated is the safe harbor approach that Brad referenced earlier, and I think said is more tinkering with negligence law than an absolute shield. And basically what is being discussed is the idea that if you were a business, school, or nonprofit, and you generally operated in compliance with federal, state, and local guidance and directives, you get protection. Again, it's only a safe harbor, nothing absolute. Further, whatever protection is afforded in everything that I've heard discussed wouldn't be available if the defendant engaged in egregious behavior. So if there are allegations of gross negligence, intentional, willful, or wanton behavior that can be proved, any protection would fall away. And so truly bad actors wouldn't get any protection. So the protection would only be as to claims arising during the pandemic, during the pending crisis, and it would be limited to COVID-19 claims. So in that sense, the protection isn't a permanent change in tort law either. So I think what we're talking about is really limited temporary protection. To the question several have raised and you posed, why is this needed? I think it is primarily to discourage the mass filing of these claims and to make clear, and perhaps with some pleading standards up front, that because of this very, very serious causation impediment to these claims, that some things may need to be shown up front before people can proceed with them, so that we don't fill the courts with a lot of frivolous claims. And I think also the concern is, obviously, once one of these claims is filed, you almost impose liability on the defendant already because of the cost of defending these cases. Now, one more point I want to make that I think is very important to this discussion. As Joe explained in detail, state workers' comp programs provide the exclusive remedy for workplace injuries sustained by employees. And I wanted to say in response to something Joe said is that none of the proposals that I've heard about would change that. The discussion that I've been hearing at the federal level is that workers' comp laws would be explicitly not affected. And I would encourage everyone to look at the several states that are now considering legislation of this sort at the state level and the bills that have been passed. For example, if you look at Ohio and North Carolina, they've both passed bills. They explicitly say, we're not touching the workers' comp system. That remains as it is, not affected in any way, continues without any impact. And I think that's what we're going to see in these bills, is that none of these laws being proposed would really change very much with respect to employees. Now, of course, if an employee who believes that he or she has been injured decides to go to court instead of seeking workers' comp relief, and the courts allow him or her to proceed, notwithstanding the exclusive remedy rules for workers' comp, the protective rules that we're talking about that would apply to everyone else would apply to them as well, I suspect, under this legislation. But I don't believe that there is an intent on those who are urging passage of this type of legislation to really create any change in the workers' comp system. Thank you.
Thank you, John. So now I'd like to turn to you, Bob. As the former chair of the New York State Workers' Compensation System, why are you calling for a national fund similar to the 9/11 fund? Where do you see the cracks in the system that you think such a fund would fill?
Well, thank you, Esther, for including me in this distinguished panel, and to listen to Brad and Joe and John has really been enlightening. As Joe pointed out, workers' comp traditionally has covered accidental injuries and certain enumerated occupational diseases. Every now and then, however, a workers' comp system is asked to bend somewhat or to accommodate special circumstances, such as it did at the time of September 11th. Certainly not a foreseen situation that planes were going to, hit the Twin Towers. But picking up also on what John indicated and also on what Joe indicated, the proposal or why I would propose and support a federal fund is not to replace a workers' compensation system, but rather to supplement a workers' compensation system. And why is that? As you point out, Esther, there are cracks in the system. And I'll go through that rather than try to summarize that entire 25-page memo that I did. I'll try to keep it within the time allotment. So what I did was I initially researched the case law dealing with contagious diseases. And it is true that in New York State, contagious diseases such as tuberculosis has been held compensable either as a occupational disease in the case of nurses and other healthcare workers, or as an accidental injury in the case of the Middleton case, where there was a corrections officer who secured it. So there is a basis for it. However, as Joe pointed out and John pointed out, there is the question of exposure. Now, I believe, and I've said this from day one, that I have a firm belief that the Workers' Compensation Board of the state of New York will take every step possible to achieve fairness with regard to these cases. Both Executive Director Mary Beth Woods and General Counsel David Wertheim were present with the agency at the time of 9/11, so they are familiar with how the agency responded to 9/11. And also, Chair Rodriguez has sent out a letter asking carriers to pay without prejudice or to accept these cases. Now, at the time of 9/11, we did the same thing. We asked for payment without prejudice. 40% of the cases were contested. And picking up on what Joe had indicated, I suspect that we're going to see more than 40% of these COVID cases contested. So I think the board has done everything that it can within the powers that it has. I mean, it has some additional powers where it could assign particular judges to the case under Section 20, or it could retain certain doctors under Section 13 to render opinions. But I think that administratively, the board has done quite a bit. I also took and I reached out to some retired law judges that I knew and asked them, what they thought of the challenges associated with COVID. And across the board, the judges indicated that they would like to see a presumption. So I started looking at the presumptions around the country as well. And there's been a patchwork of presumptions, different language varying from state to state. And I think that Will Rabb, who's a reporter from Work Comp Central, has done an excellent job of keeping the industry abreast of the various presumptions. Presumptions can either be a rebuttable presumption like they have in Illinois, or as one retired law judge shared with me, he would actually love to see a conclusive presumption for certain healthcare workers. So some people will file claims, precedent will allow those claims to be established, but not everyone is going to win in their cases at the Workers' Compensation Board. Furthermore, not everybody is covered under the Workers' Compensation law. Each state has a statute which indicates those people that are covered and those people that are not covered. In New York State, for example, volunteers are not covered. And there was an article in the New York Times indicating in early April, I think it was, that 90,000 people had registered with the New York State volunteer hotline, 25,000 of which were from out of state. I recall in the days and weeks after September 11th, I spent time at Ground Zero. I spoke with the people that were working on the recovery, on the rescue at that time, and the cleanup. I was amazed at the number of people that had come to, Lower Manhattan at Ground Zero, people from around New York State, people from around the country, from other states. So what did New York do relative to that? Well, New York, because obviously volunteers were not covered at the time of that cleanup. Others, sole proprietors, are not covered either. So what did New York do following 9/11? Well, Article 8A was created, which redefined people that would benefit or be covered, and they were participants. That was a new category of individuals. So perhaps, as you point out, Esther, this is not only a national pandemic, but an international pandemic. It's not, for one state. So I think that a federal fund is necessary, again, not to replace a state system. In fact, I don't think the feds could replace a state system. I think it'd be unconstitutional. And a law professor from the University of Wyoming College of Law, Mike Duff, has written extensively on the interplay between the feds and the states in terms of the workers' comp system. So, a federal system will plug in and cover those people that are not covered under the state system. And it will do it on a national basis, not just in one state or another state. So essentially, that's why I support the federal fund.
Thank you, Bob. Well, now I'd like to bring the entire panel together so that we can discuss the issues that have been raised in these presentations. And so first, I would like to ask Brad, you, Joe, and Bob, if you have anything you would like to add concerning the issue of liability protection for employers, because we've now heard from John, and then for the audience, we will then look at the same question with respect to the fund. So first, I'd like to ask Bob and Brad and Joe concerns that are raised, questions that they have, things that they think need to be added to this discussion. So just let me know which one of you wants to start.
I'll jump right in. Thank you. So John mentioned that workers' comp is not being, or alluded to the fact that workers' comp is not being considered as part of these policy proposals. I've seen just in the past week, partners at white shoe law firms quoted in the press lamenting the fact that workers' comp immunity is not getting traction in Congress. I'm happy that it's not getting traction in Congress, but when it comes down to it, they wouldn't know that it's not getting traction in Congress if someone wasn't out there shopping it around.
So I'll just say I agreed with John's point on causation and the difficulty of proving that, and it does track with my understanding of the federal legislation that it would just be something like this limited safe harbor. But things are happening at the state level that I think we should be wary of as well. Again, I don't know that much about the workers' comp system, but that Washington Post article talked about a Connecticut statute immunizing nursing homes altogether from liability, which is concerning. So I think we should keep an eye on legislation both at the federal and the state level and be on the lookout for overreach like that.
Yeah, traditionally in the New York State workers' compensation system, it's been a very high burden to prove any direct lawsuit against an employer. Essentially, it has to be an intentional tort. So I'm not sure if it was John that said this or Joe that said this earlier, but essentially the workers' compensation system is a 100-year-old immunity shield already in place for employers in the workers' compensation workplace injuries. I do believe that with COVID-19, there will be discussions at both the national level and the state level over whether or not particular actions or inactions by an employer will provide a sufficient basis to avoid the workers' compensation law. I think we've seen lawsuits in at least a few states where the estates of deceased workers have brought direct lawsuits against employers saying that the actions of the employer were egregious enough to avoid the workers' compensation defense. John, Brad, Joe, have you seen those suits or anything about those?
I've seen some reporting on that, but I agree. My understanding of the New York workers' comp bar is that the intentional act exclusion is very narrow, and it has to be basically, purposeful, spiteful, malicious action. Other states, New Jersey is a little bit more lax than that, but New York, Pennsylvania, and Illinois, a lot of states that we're familiar with have a very, very narrow interpretation of the intentional act exclusion.
What about the class action lawsuits that we've heard about against McDonald's that have been brought by employees, I think, in California and Illinois? Are any of you familiar with those suits as well?
COVID specific?
Yeah, COVID specific, not seeking damages for injured workers, but essentially trying to declare the workplace unsafe and they have it declared a nuisance and shut down. Have you seen those stories?
I have
Yes.
not.
Yeah. John, what's your thought
No,
about
I have seen those, and those are, at least the McDonald's case, my recollection is a public nuisance case. I think there's a damages dimension to it. But a lot of times those sorts of cases are aimed more, as one of you just said it, aimed at shutting down. That's the tradition in the public nuisance arena is shutting down a facility because it's purported to present a health hazard of some sort. Although in recent years there have been a lot of efforts to stretch that doctrine, I think, beyond its original intent.
John, have you seen any discussions that the immunity statute or the safe harbor, and I'm not sure what the difference is between immunity and safe harbor, but relative to any whistleblower complaints, retaliation complaints, discrimination complaints that would arise in the workplace?
No, I have not. Most of the discussion, it doesn't mean there aren't proposals floating around out there, because as several of you have mentioned, there's a lot of people with a lot of ideas. But in terms of, if you look at the correspondence, in the last couple of weeks, there have been these widely circulated letters from businesses, from colleges and universities, and from some nonprofit organizations. And their focus really has been in large part on the sorts of exposure claims that I think most of us have been focusing on the discussion today.
I would like to point out here, someone said, that or suggested that the purpose here is to protect businesses from ruinous liability expenses, and I think that it's a matter of public policy. Who do you want to face the ruinous expenses? The employers who procured insurance to cover for those expenses, or the individuals, the workers, the people who might have slightly lower dividends at the end of the year, or the people who are going to lose their house or their apartment, or not be able to pay for healthy food for their kids to eat. This is a policy decision, and when it comes down to it, these risks have been calculated. They've been considered by armies of actuaries and underwriters and forecasters and risk management folks. And I'm just talking about the workers' compensation system. I see the workers' compensation system and in New York alone. It is an industrial complex. There are a ton of people who are making a ton of money, including myself. I'm not making a ton of money, but I am a workers' compensation lobbyist. At least my salary doesn't come out of premium dollars. We're funded by our affiliates, but there are a lot of people earning a living on this system. And the idea that that they somehow weren't prepared, in my mind, should not let them off the hook for the liability that they incur. And to the idea that that workers' comp isn't part of this, or that it's just a little tweaking around the edges. When it comes down to it, you have to prove negligence, right? I would imagine there's a bunch of labor and employment folks on this call. I haven't really paid a whole lot of attention to negligence since I took the bar exam, just because it's not part of my practice. But when it comes down to it, there are elements. You have to prove the elements of negligence. And if an employer shows, or a business shows that, and I shouldn't say employer, because employer won't be facing negligence liability from an employee in New York State. As Bob mentioned, it's nearly rock solid. I mean, short of your employer punching you in the face, it's a pretty high standard. You're going to end up back in the workers' comp system. So for customers, right, for anybody who might happen into the business, they have to prove negligence. And Brad touched on it. This is not an objective standard. It's subjective under the circumstances, right? And you have to prove that there is a duty. You have to prove that the duty was breached. And on top of that, there are defenses like assumption of risk. And I live in outer borough, New York City. I was I had occasion to leave the house to go to a hardware store. I get to the hardware store and I look in, and here I am, masked up, social distancing. I look into the hardware store, and there is not a person in that store that has a mask on. There's signs all over the place: wear the mask, maintain social distancing, and they're not doing it. And I had a choice: do I assume the risk and go in there because I know that they're not doing what they should do, or do I not go in? So if I were to contract it as a result of being in that store, that's a defense that the business owner has. The fact that they don't even want to consider or allow the possibility that someone could assert their rights, to me, is extremely problematic. And just another aspect of this, these business owners are being, for lack of a better term, they're being whipped up. They're being told that there's a problem here that must be addressed. And I imagine that some of the same reasoning is being used in conversations with these business owners. Many of them probably believe that they need this, but ultimately they do not. The other thing is, good luck finding a lawyer to take your case. Most of these, unless you have the money to pay them hourly, most personal injury lawyers work on contingency fees. They're not going to put the time and effort and resources into these cases, especially not the small hardware store on Staten Island. It's just, I don't think that it's a realistic fear here, and because of that, I suspect that the real goal is things like workers' comp.
Joe, to pick
Thank you.
up.
I'm gonna interrupt you here for a second. I apologize, but I do want to give everybody the code that they need for the CLEs. The code is ILR 1966. It's ILR 1966. I would like to go on to the next question, which is the National Fund. And then we have a number of questions in the Q&A box, which I would like to get to as well. So Bob, with your forbearance.
Sure.
I'd
I
like
was hoping to ask another question because I'd take up all the time, so no one would ask me any tough questions. But I guess you saw through me on that one.
I have lots more questions I'd like to ask too, but let's do the fund question, because I think that's also a very important question. And so we did talk about it. And so now I would like to ask Brad, Joe, and John, is there a take on the fund that you would like to discuss as a member of this panel?
I'll just say very quickly, because I don't have anything terribly sophisticated to say about this, but the question with respect to any of these funds is, how is it funded? Who's paying for it? It's one thing to talk about the BP oil spill fund. Well, the defendant is funding that, or something like the vaccine injury compensation program. That's vaccine manufacturers. But something like this is like the 9/11 problem on steroids. It's a national problem, and everybody would have to pay in. And as a practical matter, that means some kind of legislation would have to be adopted. And I just don't see this Congress having the appetite to fund, more of what it regards as stimulus or compensation programs in the wake of COVID. So I don't see it happening at the national level, and it's impractical at the state level. This truly is a national and indeed a worldwide problem. So, unlike a lot of other funds, which can be funded out of the proceeds of litigation, a court can order defendants, or as part of a settlement, the defendants can agree to establish a fund. You don't have anything like that here, so it's got to be a legislative solution.
John?
I would echo those same sentiments that 9/11 is an interesting precedent for this, but this is, as Brad was saying, 9/11 on steroids. It's nationwide. The impacted area is nationwide, and so the number of people that you have who have been touched adversely in some way by this controversy is very broad. And you do worry that, if there are individuals who have been injured by these events, who are struggling mightily as a result of it, that there's a point at which I think Congress is going to stop addressing the financial aspects of this. As we saw in 9/11, there were efforts to expand those payments to others who had been adversely affected by other terrorist events and so on. And there came a point where Congress just wouldn't go any further with that. And so I think really the need in this regard, and I'm not sure I have thought enough about this to say anything very helpful on the subject, but I do think there's a need for those who are interested in this to really figure out the pinpoint group or groups that have been left out of this who are in need of assistance and support. And I also think that approach is going to be much more productive if it can be achieved than any litigation approach, because I think that the litigation, if it amasses the way a lot of us think it will take years to resolve. And if people are in significant distress as the result of it right now, as I'm sure many are, providing compensation sooner rather than later is going to be critical.
Joe, is there anything you'd like to add before we move on?
Sure. The idea of a fund is something that we're certainly open to, but there are some concerns. The first concern with a fund is that any continued conversation of a federal fund or a federal bailout gives people the excuse to not act. Bob mentioned 21A, and 21A is, or he mentioned the concept. 21A is a section of the workers' comp law here in New York State where a carrier or a self-insured employer can pay for up to a year without admitting liability. If people think that the federal government is going to come and rescue them, maybe they'll pay for up to that year without admitting liability, without having any finality to the case. Maybe the policymakers here in New York will decide, hey, let's wait for the federal government to come bail us out. One problem with 21A is that once the carrier starts paying, it's very difficult for an injured worker to get a hearing. And 21A doesn't say that they have to pay at 100% of at 100% of what that worker is entitled to. It says that they have to pay. So they may only be receiving 25% or 50% of the total benefit that they're entitled to, and still the employer doesn't admit liability. And the board looks at those cases very often and says, well, you're getting paid. We're not going to give you a hearing. It's not necessary. Go figure this out. And it's another tactic for the litigation by attrition. Another concern, or not even a concern, but let's be realistic. And I work for an organization that supported wholeheartedly the VCF, and it's a good program. But let's not lose sight of the fact that from the policymaker's perspective, the Victims' Compensation Fund was as much to protect the airline industry as it was to protect the people who were hurt and who were hurt by by their exposure to, well, not only their exposure, but hurt on the day and then hurt based on their exposure after the day. So let's be realistic and open about the fund. So there are some concerns here, and like I said, though, my biggest concern is that it's going to give people an excuse to, let's just wait and see. Maybe the federal government will bail us out. And I agree with John. It doesn't seem like there's much of an appetite here for that.
So we have many, many questions in the chat box. Bob, do you want to give a quick response, or can we go to questions?
Just a quick response. I think all of those points are absolutely spot on, and those are the issues associated with any federal fund. I think it has to be clear that a federal fund does not divest a worker of his or her rights under their state system. It does not relieve a carrier or employer of their obligation to pay under a state system as well. And I would also point, besides to the September 11th VCF, I would also point out Article 8A of the New York State Workers' Compensation Law, which created a new category of recipient under the workers' compensation system, the participant, who was deemed an employee of the uninsured employers fund. I find it disturbing as a country that we would allow the nurse to receive benefits under the workers' compensation system, but the volunteer in the hospital who gets COVID doesn't get any benefits because that person's not covered under a workers' compensation system. So really the intent here was to provide for those people that fell through the cracks, as opposed to provide a reason to delay payments to others, and not just volunteers, but there's a number of others as well. Thank you, Esther.
I mean,
okay, I'm going to go to the, excuse me, I apologize, Joe. I really want to go to the questions.
The risk is that neither the nurse nor the volunteer gets the benefit.
Okay. So let me go to some of the questions now. We have a very active group, lots and lots of questions. So one question, some businesses are considering employee COVID-19 releases. Is such a waiver or release of claims a good idea? Could this be seen as an interference with the employee's workers' compensation rights, such as an exception to the exclusivity rule? Would that apply? So what do you all think about this waiver for COVID-19?
I think it's not valid under the New York State Workers' Compensation Law. The only time that a worker can release his or her claims under the New York State Workers' Compensation Law is a release that has been approved by the Workers' Compensation Board of the State of New York. So that's my understanding. I'm not sure if Joe or John or Brad have a different understanding.
I agree, and I would go one further. I think that worker might have a cause of action under the retaliation protections under the Workers' Compensation Law. What is that, Bob? Section 120?
Section 120 and Section 241 if it's a non-occupational condition.
Yeah, I would just add that some of the waivers that I have seen that are related to COVID-19 don't go to claims, workers' comp claims, waiving rights in terms of litigation, but have been focused on other issues such as disclosures to the employee about procedures, about medical testing and things of that nature. So I just want to make sure we separate those. I don't think you guys are talking about if they're not dealing with workers' comp type rights, but instead are involving disclosures with respect to procedures that will be used in the facility, the office, whatever you're talking about, that's in a different category.
Okay.
Although those would have to be negotiated with the union.
Here's another question. What about the entertainment industry, specifically for film shoots in New York? Would they be covered under the New York State Workers' Comp Law?
So I would say that they are, but it comes down to the proof. And the indications are that the board is going to treat this like they've treated tuberculosis cases in the past. That and maybe not even as strictly as they've treated tuberculosis cases in the past. They are certainly covered. It's going to be a matter of whether they can prove, to the standards that the Workers' Comp Board establishes here, that they got it at work. So I think that the more facts that they allege showing that they were likely to have gotten it at work, the more likely they are to be covered. Like they were working outside the home during any type of period of closure or staged reopening or phased reopening. Their level of interaction with the public, walking on the streets in New York City, I'm sure everybody on the panel has experienced. You get someone who's working on a film shoot to ask you to please stop, don't walk down the street, we're filming. Those people who are out there interacting with the public the more facts that they can allege, the more likely I think they are to be covered. But they should be encouraged to file. It's important. There's not even a hint of a chance if they don't file.
A couple of additions to what Joe just said. Number one, what would be interesting here is how the board views and whether the board distinguishes between essential employees, essential businesses, and not essential employees and non-essential businesses. It's early to say whether or not they will make that distinction. In the case of out-of-state film producers coming into the state, what's interesting here is, let's say that someone contracts the COVID or is exposed to the COVID here in this state, but then returns to their home state. Will they be filing a claim in their home state, or will they be filing a claim here in this state? And will New York exercise jurisdiction if the alleged exposure took place here, but the actual disease manifested itself when the person went home? And then the last point is, hopefully the employer in that case had coverage to provide coverage not only in the home state, but also in this state, because there could be issues that would arise relative to coverage of those claims as well.
Okay, another question which actually goes to the issue of immunity. So the question is, given that over half the workers in the United States are subject to arbitration clauses as a requirement of being employed, and the Supreme Court has repeatedly affirmed that an employer has the right to require those arbitration clauses in which you waive your right to bring lawsuits under various statutes. How does that fit into the question of immunity, since forced arbitration or the requirement that arbitration and class waivers, and we know that they can't give up workers' compensation, so why would you need a liability bar, given that so many workers are covered by arbitration clauses?
Well, assuming it may be directed to me, I think that this really goes back to the point I made earlier. The legislative proposals I've seen and what's been out there in the state would not apply, I don't believe, to arbitrations. They apply to litigation, lawsuits. That's what the focus of this is. So I'm not sure I see the connection between the two, because they wouldn't affect arbitrations. So
no, the point is that you must go to arbitration with your employer. You may not bring a lawsuit or be involved in a class action against your employer. So
understood.
But wouldn't that be ironic? Employers or businesses generally have been pushing for arbitration, and then they get some kind of legislative liability shield against civil liability, but then they have arbitration liability. That would be ironic.
Yeah.
And of course, in major sort of class action arbitrations, the number of individual hearings that have to be held are just amazing. And that's the other side of the coin for this situation. John, another question came in, and the question is whether you see, as part of this liability package, if it eventually does go to Congress, whether there would be other labor and employment laws that it would be applied to. For example, the WARN Act or some other labor and employment law.
Again, since we haven't seen the bill, I don't know what will be in there. There has been some discussion about WARN Act modifications specific to COVID-19 to deal with the timing problems and the speed of some of the closures and so on. So let me just say, I would not be surprised to see provisions like that in there, but most of the attention that I've seen has been given to exposure, product liability, and a few things of that sort. Those are the main things that have been emphasized in the business community letters to the Hill on these issues.
Another question. We have a few minutes left, and I believe that your evaluations have been posted. So while you're doing your evaluations and filling out your code for your CLEs, let me continue to ask some of the questions that have been put into the Q&A box. One of the questions raised was that under workers' compensation, there's a limited period at which you get benefits and you've been determined to have a particular injury. We do not know the long-term effects of COVID-19. We're beginning to see inflammation later. We're seeing people with heart conditions. We're seeing strokes. So would a national fund be appropriate given that we do not know the long-term effects of this disease that keeps on giving?
Well, that's a tough one. I mean, I think one of the aspects of a national fund is for data collection as well, collecting data from around the country. But the obligation, as Joe pointed out, if in doubt, still file your claim at the state level. And that question is spot on in terms of, we don't know what the long-term consequences of COVID is. We don't know whether or not someone's going to have respiratory problems 3 years from now, cardiac problems 3 years from now, circulatory problems 3 years from now, or 5 years from now, or whatever. I think following September 11th at the state level, I think that there were thousands of claims that were filed as a protective measure. Just get the filing in there. And I think my advice, although this, obviously there's a big disclaimer on the outline I did, it's not intended to be legal advice, you should seek the services of an attorney, etc. My advice would be to consult with an attorney and give strong consideration to filing a protective claim, and to follow the advice on the June 1, 2020 guidance letter that the Workers' Compensation Board posted on their website. Joe, anything to add to that?
No, I think that's it. I think people should be encouraged to file. As far as I can tell, there's no prejudice to the worker if they file prophylactically. That they know that they were exposed to somebody who later tested positive. They have reason to suspect they're a healthcare worker in a facility that treated COVID-19 patients. If they have, and to be clear, it's not in our interest to have people getting benefits who didn't and who weren't exposed at work, right? Every dollar an employer pays for workers' comp is a dollar that's not available at the bargaining table for wages and benefits. So I just want to be clear about that. But protecting these workers or getting these workers to file prophylactically, as far as I can tell, there's no prejudice to them. They have up to 7 years to provide the medical evidence, having these claims in, can help them or their family if there's ever a proof contest in the future. If there is that federal fund and there's, records are destroyed, we see September 11th now is almost 19 years ago, and we're still dealing with affiliates who have members who were sickened from exposure, but not direct exposure. They were exposed to a vehicle that was down there that was never decontaminated, that this person wasn't hired until 2002. They were in that vehicle that wasn't properly decontaminated, but there are totally inadequate records where the vehicle was when it was there. And they're coming down with cancers that are really 9/11 diseases. They're things that are specific to exposure to the dust from the World Trade Center. So, in an attempt to avoid that type of situation 19 years from now, we're encouraging folks who are exposed or suspect that they were exposed to file.
Right. Joe, maybe you know the answer to this, but I know that following September 11th, NYCOSH did a great job of educating workers as to the filing requirements, and our good friend Joel Shufro really led that, I think, back 20 years ago. I'm sure, does your office have such an educational program going on right now relative to COVID?
Yeah, so we have been focusing on sharing materials with affiliates and affiliate reps. NYCOSH has a robust COVID-19 program,
Yes.
that's geared more towards individuals, but we're certainly working hand in hand with them.
Well, our time is up. It certainly seemed to move very quickly. I want to thank my wonderful panel for your willingness to participate and sharing your thoughts and your ideas. I think this issue is not going away. I think it is something that we're going to see be revisited several times, and we may be coming back as things progress and move forward. I would like to ask the audience to please fill out the evaluation forms. We need the evaluation forms so that we can give you your CLEs. In addition, please remember to add the CLE code that I announced earlier in the program. I hope that you will all join us next week, actually next Wednesday, the same time, for a discussion of the intersection of the ADA and the ADEA when it comes to older workers and the issue involving older workers. And now I can't see my audience, so I don't know how many of you would fall into that category, but my guess is that there are a few of you who would. So I hope you will all join us next week for a discussion of what happens when businesses open up and they have vulnerable workers that the CDC has said can be seriously impacted if they catch COVID-19. Again, I want to thank you, Bob and John and Brad and Joe, for a really, what I found very interesting, and I hope everybody else did too, discussion of the issues. And thank you all for joining us. Please fill out your evaluations. We learn from them. If you had come to my in-person programs, you know the first thing I do is read the evaluation. So I look forward to reading your evaluations. Thank you all very, very much for participating, and have a good rest of the day.
You're welcome. Thank you, Esther.
Thank you.